We are back again with Doug Rohan of Rohan Law to talk a little bit about this FSU ACC dispute, maybe is the best way to put it. And Doug, we're a week early. We thought we'd be here later next week. So let's jump right into it. Why are we here today?
Yeah, we weren't going to do anything until the hearing coming up March 22nd. We'll talk about that in a minute later. But right now, there was some need to come on and talk a little bit more because there were been two more filings in Florida. So the first of which was the ACC filed an objection to the plaintiff's first request for discovery. That was on Friday. And then FSU has filed a response to the ACC's motion to dismiss or stay. So even though these came very close in time, they really weren't necessarily related to each other. Someone was asking if the motion and the reply was filed in response to the discovery. No, these two things were on a trajectory to get filed when they were filed, independent of each other. So again, here we're in Florida now, and we're talking about the ACC's desire to not answer discovery, and we're talking about FSU's response to the ACC motion to dismiss or stay, which is going to be heard on April 9th.
Is this unusual? Was this atypical?
No, this is very straightforward. Again, what you've seen already now happen several times in both North Carolina and Florida. Somebody files a document, then there's a response to that document. Then there's, sometimes objections. So these are standard filings in typical litigation. What is a little unusual in this situation is kind of where the two parties are in terms of going at each other. They're very testy at this point. We'll get into some of the details of the filings later on. But what we're talking about here first is basically ACC saying, look, FSU has propounded discovery. Propounded is your first SAT word. They've sent us discovery requests, and we don't want to answer those. And so there's a couple curiosities that are coming from this. The first of which is we didn't see this filing by Florida State in North Carolina because the two parties agreed to play nice and said, look, we have this motion to dismiss, we have this motion to stay, so let's just jointly agree that we're not going to answer discovery in North Carolina. Well, when it came time to have that conversation about the Florida case, FSU was not so cordial, was not so friendly. And so when the ACC said, hey, we have this motion to dismiss pending in Florida, let's not answer discovery, basically Florida State said, get the hell out of here. We want our documents. Let's start talking about what's in those records and those contracts.
I'll ask you to speculate as to why, but do you think it could have to do with Florida State thinking this needs to be tried in Florida, and so we're going to press on in Florida?
I think that's part of it. I think the reality is that FSU is looking for any pressure point that they can exert to try to get this to the bargaining table. Again, we've talked about it from the beginning that this is likely to result in settlement. The sooner that the parties can get serious about settling this case, I think the better for FSU in particular.
So let's look at these maybe one at a time. We've talked about jurisdiction and venue before. Are there any new developments there?
So this was the first thing that was interesting in the objection to responding to this discovery. The first thing the ACC says is, look, we still don't even agree that we're subject to the court, and so we don't feel like we should be obligated to spend hundreds of hours putting together these discovery responses. So FSU is pointing out that, this discovery has been sent, the litigation is ongoing, and the ACC is asking the judge to first agree that discovery isn't ready yet because we're still deciding whether or not this case is even going to be heard in Florida. And I don't think that's an unreasonable request, and frankly, I do believe the judge is likely to go ahead and agree that for the time being, we're going to wait and see what happens on April 9th before you have to engage in responding to these answers.
So if you guys aren't following Doug on social media, make sure that you go over to Twitter specifically. I mean, if you're on a Facebook or Instagram, you can certainly follow there, Rohan Law PC, but Twitter or X, whatever you want to call it at this point, is definitely where you can dive in a little bit more to some of these thoughts. But I saw some of your tweets. Talk to us about this idea of FSU not playing fair.
Yeah, so it's what we were discussing before. FSU and the ACC agreed mutually to set aside discovery in North Carolina, and then FSU asked that the ACC go ahead and respond now in the Florida case. So I think at the end of the day, like I said, the judge is most likely going to go ahead and put the discovery on hold. It's typical, it's standard, but it's just another example where FSU is not letting its guard down, and they want to make sure that the ACC understands they're here for real. They're here to play this game until the end if it has to be.
Yeah. So some of the specific discovery requests that you kind of have notated, there are blanket objections and then specific objections as well. Can we talk about that a little bit?
Yeah, so what happens when you're objecting to discovery is first you say, look, none of this is relevant or none of this is appropriate because of X, Y, and Z. So the ACC lays out a few reasons and a few items as to why none of the discovery should be responded to, one of which is what we've already talked about, jurisdiction and venue. But they also go on to claim that the statute of limitations applies to these claims, and so they're not ripe. There's reasons why there should be more strict time limitations. Look, discovery is designed to be very wide ranging. Everyone has seen the movies where the attorney stands up, objection, irrelevant. There's a lot of things that will ultimately be irrelevant that gets provided in discovery. But the standard for discovery is, will this information be admissible, or is it reasonably calculated to lead to the discovery of admissible information? And that's why the judge is oftentimes going to grant wide latitude in what needs to be produced. Now, the one thing that FSU is contending with is this issue of the statute of limitations, which we'll get into later, and whether or not it's appropriate for things back in 2011, 2010, 2009, even 2008 to be produced when we're talking about a breach of contract or a breach of fiduciary duty claim.
So that's a lot of the general info on the ACC filing. I know that you've tweeted a lot about this. Noles 247 has the full document for people to check out. They can, I think, find a link to that on your Twitter as well that I've seen be posted. But there's also then the filing from Florida State yesterday. Now, this is FSU's board's response to the ACC's motion to dismiss or stay. Let's talk about this a little bit.
So this is where the gloves really are starting to come off. I mean, you can just look at the opening paragraph, the opening statement from Florida State lawyers said this motion is mostly a cardinal mistake. What they're talking about there is cardinal, the reference to the compass heading or the cardinal heading on a map. So what they're saying is this is a large and important, poignant mistake. And they're disputing the facts on a motion to dismiss, relying on failed assertions from the ACC's unprovoked lawsuit initiated the night before the FSU board filed its comprehensive claims, and that those claims somehow nullify our claim. So what they're basically saying is that, and then they went on to say, and that this complaint that the ACC filed in North Carolina was filed in direct violation of the ACC's own constitution, and that this was a naked but errant effort to anticipate the claims of FSU. So, I mean, from the beginning, they're throwing down the gauntlet saying, look, the ACC has made several missteps in this litigation, the first of which was they breached their own constitutional bylaws and rules to file it. They did so in anticipation of an FSU suit without knowing what the FSU suit was going to claim. And then in their motion or in their filing, they're contradicting themselves on specific issues that are relevant to the controversy. So from the outset, ACC is on its heels based on the FSU filing and allegation, but FSU is not pulling its punches.
So how does the state of Florida, or what is the standard that they have when determining whether or not to dismiss any kind of complaint or case?
So again, both parties are throwing a whole bunch of stuff in all these pleadings, but it helps as we're going through this process, and why I love being part of this process with you, to refocus us on what is going on. We love all the dirty details and the tea, but let's take a step back again. What we're talking about right now is the ACC asking a Florida judge to dismiss FSU's complaint. So what FSU cited to is that there are standards based on case law on how a complaint can be dismissed. The first is that the requirement on the complaint is that FSU needs to put out all of the claims sufficient to establish what the violation of the law was. So the complaint must set out a basic set of facts that are meeting the elements of the claim, in this case, breach of contract, breach of fiduciary duty. Then the second part is that when there's a motion to dismiss, as we have here with the ACC, the judge has to presume that every element or every allegation in the complaint is true. We're not there yet. We're going to have death testimony. We're going to have discovery. We're going to have evidence. Might have a trial. But for now, in a motion to dismiss standard, let's assume everything FSU stated is true. And then the third part of that is the ACC then must establish that even if everything was true, there is not sufficient basis for this case to move forward. And that's a very high standard. Not a lot of cases get dismissed, especially not with prejudice, based on those standards. So here we have a situation where I do believe that there are sufficient elements of the breach of contract and the breach of fiduciary duty laid out. And if we're assuming that those issues are correct as alleged, then I don't see how the judge agrees that this is something that should be dismissed at this point.
Going big picture, would it surprise you if, maybe a little less if the North Carolina case got dismissed, but would it surprise you if that got dismissed as well?
Correct. I think it's much more likely if FSU gets a win, and that's a big if, that the win is North Carolina deciding to stay this case and Florida proceeding with the case.
All right, so remind us quickly again what the issues are in the complaint.
So the biggest problem that FSU has, there's two basic issues. FSU filed a complaint asking for a declaratory judgment action that the grant of rights is invalid, and that it is invalid for a host of reasons. And the easiest to grasp right now are that there was a breach of fiduciary duty on the part of the ACC, and that the ACC has breached its contractual obligations. If either of those elements can be found, then the court is authorized to extend that to a determination that the grant of rights is not enforceable. So again, the complaint has to set out reasons legally for the court to find the grant of rights is not valid. So that's what the original complaint was talking about.
And now we've talked about this in the past, but is this where the statute of limitations issue comes in? Are there limitations on when you can even bring claims like this?
Yeah, so there's a lot of hay that's been made. A lot of people have been talking about this concept of the statute of limitations, and the time has passed. So to refocus the discussion there, the statute of limitations on a breach of contract is 5 years. The statute of limitations on a breach of fiduciary duties is 10 years. That's why you're seeing the ACC kick back so hard on this idea of the ACC having a fiduciary duty to FSU, because that extends dramatically the time period that the court can get into these issues. But the other part, and I've seen a couple of people post some wrong information about this, the breach of contract statute of limitations is not from the moment that the contract is signed. So it's not related to only the 5-year period after the signing of a contract. It's from the time the breach occurred. And that's a much more subjective and speculative issue. So it is 5 years from when the breach occurred. But there's another element that I want to make sure everybody understands, and that is that the statute of limitations on occasion can get tolled or extended. Not like the Florida tolls you have to pay, but tolled as in being stopped. And in that situation, fraud is one of the reasons why a statute of limitations can be tolled. So that's why FSU is making such a big deal out about this ultimatum that may or may not have actually existed. If the ACC lied to its members about any elements that were required to create this contractual agreement, then it's 5 years from when the parties knew or should have known about this fraud or about this allegation. And so that extends it. Now, there's a maximum period of 12 years from wherever the fraud occurs. It doesn't extend it indefinitely. But what it takes is a 5-year statute of limitations and extends it up to 12 years from when you knew or should have known about the fraud related to knowing or should have knowing about the breach.
Yeah. So we're technically outside of those limitations when you look at the 2013 stuff with Raycom and Swafford. But again, when the breach occurred, kind of is the loophole there or can kind of supersede some of that?
Exactly. And so that's the factual determination that the judge will have to make. And that's not proper for this stage of the litigation.
So I've seen some folks talk about latches, saying that basically FSU agreed to the deal by letting it stay in place for so long, and at this point now we're just stuck with it. Is there any truth to that?
Yeah, it's been funny to watch people's knowledge about the law grow and expand as they're going through this process. And they might think of a concept that they don't have a word for it, but then later on there is a word for it. Now they're all latching on to this idea of latches. So latches is an equity principle, a principle in equity, and that's an important foundation of our law. Going back to the Magna Carta, a lot of what our laws are based on is what is fair, what is equitable. And so this idea of estoppel by latches is this concept that, okay, maybe you did have a claim, maybe you did have some reasons why you could claim a breach of contract, but because of the long-term performance, which has been pointed out by several people against FSU, the long-term performance is an element of latches. But the other part of this is that because of that long-term performance, the non-breaching party, which that's a question to the ACC breach or not, the non-breaching party is going to be substantially harmed by any decision to assert FSU's right. So one of the examples that I was using as we were talking about this is, if there's a mom and pop store that has a company called Apple Incorporated, and ever since 2005, they've been making iPhone cases for Apple phones. Well, Apple learns about this company in 2011, and they could have asserted their rights for intellectual property in 2011, saying, hey, you can't be Apple Incorporated because we're Apple and there's only one Apple. So they're just a small mom and pop shop. They grow. And then in 2021, they're now a $10 million operation, still relatively small compared to the billions and trillions that Apple has. But Apple's finally like, you know what? Enough of this. We need to go ahead and shut this down. A judge could use this equitable principle of lashes to say, look, this was a $50 million or $50,000 company that's now a $10 million company. You could have asserted your rights back in 2010, but since you let them go for another 10, 15, 20 years, and they've built their business as Apple Incorporated, the equitable principles here would apply and you don't get to shut them down. So that's where this idea that FSU has been in this contract long term and it wouldn't be fair at this point, we've already shot that down. FSU has been paid for the performance of the contract they've done in the past. They haven't gotten any money for future performance. There's no equitable reason to suggest that just because this has been going on, that is a principle to stop FSU from taking this step to get out of the contract now.
So again, if you're not following Doug on social media, you need to go do that. We'll link it in the description. You broke down some of these points yesterday in tweets, which people should certainly go check out. Let's hit some of the highlights of those. What were your favorite parts of the filings that kind of went down this week?
Well, the first one was this whole idea of the ACC taking a vote to cure their previous filing. So they filed an affidavit in their last reply saying on January 12th, they had quorum, 10 members got together and voted to authorize the lawsuit from December of 2023. Florida State cited to several cases, and we thought this might be the case when their strongest argument in the ACC brief in support of this was some technical business decision about a board meeting. Well, the FSU brief comes back and cites to several cases directly on point, saying, no, 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 no. There are occasions, this idea that you can relate back a vote if there's some technical cure that needs to be made. You voted to approve a purchase agreement. You've already purchased the purchase agreement, but you didn't have the right number of members voting the first time. So let's take another vote to add a few more members because we've already approved this purchase agreement. We've already paid this purchase agreement, but technically we didn't have the right number of people voting. Here, what FSU is alleging is that the ACC filed this lawsuit without taking any vote. And by filing the lawsuit without taking any vote, it's as though that lawsuit doesn't exist. They didn't have the legal authority to go make that filing. There's lots of situations where a company doesn't have the legal authority to do something. So if that company does that illegal act, the proper correction is to undo that illegal act, not to go back and have a revote to relate back the corrective action. So I thought FSU did a good job of addressing this issue, pointing out some case law that's on point, and I think it makes a strong argument that in the North Carolina court, the basic response from the North Carolina judge needs to be, you never actually filed, so by never actually filing, you weren't first in time. And this is relevant to the Florida suit because that gives the Florida judge the authority to say, we're not going to recognize that you were first in time in North Carolina.
Does the now if they do that, can that fact, if this went to trial, if this went on further, should a judge not include that in his forward thinking, about the case? Like, could he hold that against them later, saying like, well, you did misstep here, or should he really just be focused on the facts of the case, not necessarily the fact that they tried to pull a cunning move prior to?
Well, that was my tweet this morning. I didn't include it in our outline of what we were going to talk about. But as I was going through a second time, and you always catch things on a second reading, there's actually footnote number 4. Go look for it or go check out my tweet. But FSU calls the ACC to task on this basically and correlates the not sharing the grant of rights, not sharing the media rights agreements, and basically calls the ACC a liar, saying, look, the ACC keeps wanting to represent to the court what these documents mean, what their intentions are, without actually letting the court see the documents. And that's just another example of the ACC deceiving the court. They use those words, deception to the court. That's a very serious allegation. So the ACC, according to FSU, continues to have this pattern of where they're really trying to call up, down, and left, right by saying, you didn't have a vote. You can't now have a vote and say that that vote is valid. So there's a credibility issue, and the way this could impact the rulings and the case litigation going forward is the judge can lose trust in what the attorneys are putting before the court and may have trouble getting the judge to extend the benefit of the doubt or extend an argument as reasonably far as the parties want. It's a very bad idea to piss off the judge that's hearing your case.
Yeah, and I almost wonder if would they have been better off to just never take a vote and say like, this was, no, our bylaw, based on the way we interpret our bylaws, we actually didn't need one. Would that have been a better angle to play than to essentially admit you were wrong by then trying to cure the vote later? I mean, I don't know. It kind of catch-22. I don't know that there's a great way to go there, but it almost feels like it would have been better to just play the, oh no, I didn't think we needed a vote here. We were able to act in this way, and this is the way we interpret our own bylaws, and maybe run that route. Again, not that that's great, but maybe would have been slightly better than where they're at now.
I think you make an excellent point, and that certainly was probably part of the discussions. Look, a lot of times we have clients that come into our office, and one of the things I explain to them is it's not dissimilar from having a football coach or a soccer coach. Every coach, every attorney might have different ideas on strategies, but we all want to win. And so this is one of those examples where there probably was a very heated discussion in a conference room somewhere of which approach do we take. And they, based on reviewing the case law and based on reviewing the evidence and the factors, advised the ACC that this is the best approach. We'll see if it works. I think that your point is exactly right. It might have been easier to argue we don't need to take a vote as opposed to taking a vote later and trying to relate that back to the December filing.
They also talked about Florida State doubled down on the race to the courthouse, basically being an admission that the ACC was trying to gain an advantage over Florida State in this race.
Yeah, I think we've talked about it on our last video, and FSU pointed it out again. The ACC stated openly that this was a race to the courthouse, and FSU lost the race to the courthouse. And here the FSU is picking up on that line in the other filing and saying they admit it. They admit that they were racing us to the courthouse. They did so without taking a vote. They did so without knowing what was in our complaint. They did so before we actually voted on the complaint. And for all three of those reasons, it was strictly a tactical advantage for them filing first. And that specific issue is one of the reasons why a judge can ignore the earlier filing because it was specifically for gaining a tactical advantage. So here, FSU is giving the ACC enough rope to hang itself on the issue of racing FSU to the courthouse.
There's also the fight or the squabble over fiduciary responsibilities of both parties that you noted.
Yeah, so this again came up because it's one of the biggest issues, I think, in this case for that relationship to the statute of limitations. ACC again is stating in their filings, we don't have a fiduciary responsibility to FSU, and FSU is pointing out the absurdity of making such a statement. Look, you negotiate on our behalf. We give you our media rights. You negotiate on our behalf. You handle the funds that come in from ESPN, and then you distribute the funds from ESPN. How can you say that that doesn't create a fiduciary responsibility? And let me say, a fiduciary duty is a whole group of laws designed to protect the underperforming, or that's not the right word, the underrepresented individual from somebody in superior knowledge and a superior position of authority. Well, here the ACC takes from FSU their media rights. The ACC is in a superior position to then negotiate all of these media deals. So Florida is going to broadly interpret this responsibility into the ACC, claiming that the ACC does in fact owe a fiduciary responsibility to Florida State and not the reverse. And we've mentioned it before. The bylaws are very clear. The Constitution is very clear. The ACC acts on behalf of its members. It's the most laughable argument to make that there is no fiduciary responsibility, but the ACC has to make it because that's what's going to cut the statute of limitations in this case in half.
So we'll wrap up, but I want to get your thoughts on this outside of everything that we talked about today. Based on your understanding, does FSU no longer have its right to votes? Like, obviously they didn't reach out to FSU to cure this vote anyway, but can FSU vote on issues within the ACC based on your understanding? Are you unclear there? Are you sure that they can't one way or the other?
I haven't confirmed it yet, but I suspect based on that affidavit that was filed in the last ACC filing, at the same time that they took a vote to authorize the litigation against FSU, it's very reasonable to presume that they also took a vote to strip FSU of its voting privileges, of its membership privileges, effectively to suspend FSU, not from performance. They state openly in the letters. We didn't even get to the exhibit letters that were part of this motion. That's another thing. Please go read the letters that FSU wrote back to the ACC about playing nice and the discovery dispute. But at the end of the day, I do think that without seeing confirmation, without getting proof from what the vote tally was, I do think that the ACC basically has taken the steps now to make FSU a neutered member of the conference. So they can participate, the student athletes can still engage in competition, they will still get paid, but they're basically a silent partner in the operations of the conference.
While this is going on, I would assume that at the point that Florida State, if they leave the conference, they certainly won't have a vote. And then if they lost on everything and stayed in the conference, I would think they get it back. I don't know if there's a timeout period or not, based on the bylaws. But I asked that because I saw yesterday with the playoff committee approving different percentages, the ACC and the Big 12 being lower. In Dellinger's article for Yahoo Sports, he mentioned that the ACC presidents voted unanimously, the ACC and the Big 12, which could have, again, just been a 10-member vote. They may not have called Clemson for that. May have called a bunch of teams that are never going to be in the playoff. So that was a leading question into thinking, well, Florida State probably just didn't even take part in that vote, which I guess any individual, ACC president could have not taken part. Cause again, you just need a 10 to do it. So you go to the 10 that you think you can go to. But anyway, that's where my brain was with that question is, would FSU really have voted for a lower share for the playoff? And my assumption is no. But again, if they don't have a vote, then it doesn't really matter.
We don't know who it is, but I suspect that there has been a clear delineation behind the scenes as to who the 10 are that are going to remain in the conference and who the 4 or 5 are that intend to leave. And if there were only 4 planning on leaving, this exclusion might push that 5th team out the door, because they're like, if you're not going to, include us in the active negotiations and discussions of the conference, then you're already assuming or presuming that we're out. Maybe this should be a self-fulfilling prophecy.
So with these filings that we have, are we any closer to resolution? What is next for us?
So we have the March 22nd hearing in North Carolina next week. We have April 9th in Florida. And then, of course, as part of this process, I did take the liberty of diving back into the Maryland litigation to kind of look at these jurisdiction venue issues and the timing of things. I wanted to kind of see how it relates. So in that filing, of course, we never got to the full litigation because the parties did go to mediation. The parties did settle. But 2 things were interesting that stuck out to that. The first of which was there is a North Carolina Court of Appeals decision related to that litigation that held 2 things that are important for our case here. The first of which was that it was proper to have this case in North Carolina. And 2, the sovereign immunity statute in Maryland did not necessarily extend to the litigation in North Carolina. So the Maryland case was strongly in favor of the ACC. They did ultimately settle that case for, I think, $32 million instead of the $51 million buyout. So there was a discount. And that it took from Maryland claiming they were out in January of 2012 to the settlement in August of 2014, a little over a year and a half, almost 2 years, 2.5 years for that litigation to run its course. So I think we'll be on an accelerated timetable here. I think with Twitter and the 24-hour news cycle, that'll help accelerate things a little bit in this case. And now FSU has to distinguish this case from the Maryland case to argue that no, Florida should be the appropriate jurisdiction and venue. There's a reason why Maryland wasn't and Florida State should. So it'll be curious to see how those arguments and those discussions go forward at the hearing. One of the things they're trying to claim is, well, Maryland was the only ACC member in Maryland, whereas Florida State is one of 2 members in the state of Florida. So that's an example of the distinction and the ways they're trying to distinguish the 2 cases, making Florida State's case stronger for this case to be held in Florida.
Do you have to have scored a touchdown in an ACC championship to be a full member in this state, or?
In this case, we're hoping not. We're hoping that is not a prerequisite.
Do you have a time? The first thing I thought of, and it may not impact our team, but do you have a time? Is that a morning case, or do you know when that is?
Right now, it's scheduled for 9:30 in the morning in Mecklenburg County Courthouse. It's not uncommon for things to start late. It also depends on how many other matters are on the calendar. So we'll see what it looks like. My strategy is I do plan to be there. I am going to plan on trying to get in the courtroom. Hearings are public. I do plan on tweeting, my observations of that hearing as it's moving forward. So do follow us at Rohan Law on Twitter and check us out, and carve out some time on March 22nd. Maybe treat it like a early March Madness date, and whatever you do at work to get a few minutes of privacy. Maybe plan to set that aside for 10 or 11 o'clock next Friday morning as well.
Perfect. Well, Doug, I appreciate you as always for jumping on and chatting with us. As we like to do, tell the folks a little bit about Rohan Law, and we'll wrap up and get out of here.
We have an Atlanta law firm based primarily on the areas of workers' compensation claims and criminal defense. So we understand that we have Florida State fans all over the place, but the Atlanta Seminole Club is one of the strongest outside of the state of Florida. So if you have friends in Atlanta and Georgia driving through some of the speed traps in South Georgia as you're going to these other ACC competitions, make sure you have our number handy. We want to be your best friends on your worst day. We know if you're calling our office, that's not a good thing. So we want to make sure we walk you through the process, explain things much like we do here with the ACC litigation, and make sure you're comfortable and taken care of. We want to preserve your rights. So look for us if you have any reason to need an attorney in Georgia. If it's not an area that I handle, we'll make sure that we put you in touch with one of our friends that can help you with your case.
Yeah, give Doug a follow on social media. Again, it's Rohan Law PC. Make sure that you click the link in the description so you can follow there. Again, does a great job. It's how I stay updated. In between these videos. So you guys comment every single time. Hey, where can we get more info? What's going on? Make sure you're following on social media. I'll do this too. If you watch this 30-minute episode and you have any questions, we do try to answer questions if we can that makes sense. So maybe we'll figure out a way to do it. Maybe we'll tweet some answers. Maybe we'll do another video. Who knows? But maybe we'll do a mailbag where we try and answer a bunch of questions at some point. So if you have questions, leave those in the comments. We'll try and get to them if they're good. If they're not good, I try to tell people send them somewhere else. But Doug, I appreciate you a ton for hanging out, man. We'll talk to you soon. Good luck next Friday.
Take care.